5 seconds. Start. It is contended before me by the Learned Counsel for the appellants on the strength of the decision of the apex court that the civil court had no jurisdiction to deal with the subject matter in issue, that the suit should have been dismissed by the courts below, and that the decree passed by the trial court and confirmed in first appeal has to be set aside, full stop. In the decision cited, the apex court was considering a case where the Punjab State Electricity Board had issued statutory instructions regarding and dealing with cases of tampering with meter, and accordingly sending bills to the respondent consumer whose meter was removed suspecting tampering, but later a new meter was installed on application, and thereafter a bill was issued and a suit for permanent injunction restraining the board and its officials from collecting the said amount was filed, full stop. Therein it was held that fundamental fairness of procedure had been followed by the board, and hence the suit filed by the respondent seeking permanent injunction restraining the board from collecting and recovering the amount demanded without first availing the remedy provided under the Electricity Act, and the instruments issued by the board cannot be entertained by the civil court, full stop. However, it was further held that ordinarily the civil court has jurisdiction to go into the disputed questions of civil nature where fundamental fairness of procedure is violated, full stop. The decision has no application to the facts of this case, wherein the appellants have no case that the respondent did any tampering with the meter installed by the board in his premises, full stop. On the other hand, the stand taken by the appellant in their written statement is that the mistake in reading has occurred for reason of mistake in connection of two phrases, and consequently there was short recording of power consumed, and that was detected on an inspection, full stop. They had also taken the stand that where there is underbilling, it is always open to them to rectify the mistake and demand proper charges, and contended that the instant case was no one where there was a defect in the recording of consumed energy in the meter, full stop. It is worthy to note that the purpose of installing the meter is to record the actual quantity of power consumed, full stop. The appellants have no case that there was any defect in the meter or that any defect existed